So the big question, I guess, why do you need to protect your business? I've put there like insurance, but insurance you might actually want to use on, like, I guess, something like life insurance. There's very little point in protecting yourself from a legal point of view after the fact, after there's a problem at some stage in the future. You always got to look at it from a protective point of view. So why do you need to do it? Well, there's some obvious ones. You're regulated by the law of the land. You're regulated by whichever jurisdiction you happen to be in, whether that's Hong Kong, Singapore, UK, United States. You've got to comply with the law. If you've got your own business, or you're thinking of starting your own business, it's almost certain that you're going to be setting up a limited liability company, and therefore you're going to be bound by the laws that relate to companies. In this jurisdiction, the Companies Ordinance, and therefore you have to comply with that law. You have no choice, or you suffer the wrath of the state and fines, or even potential criminal sanctions. There might be laws governing your industry. I've put here a few examples of specific industries that have specific laws to protect the public generally: lawyers, accountants, healthcare professionals like doctors, the financial industry, the banking industry is regulated. Of course, if you create some kind of medicinal product, if you create some kind of healthcare product, there are other potential regulatory burdens in that regard. So whether it's a regulatory point of view or even I guess a sort of criminal legal point of view, there might be laws governing whatever industry it is in which you work. That might even be, if you work in the media, copyright and that sort of thing. And then there are international regulatory frameworks that will cover you. For example, I'm still criminally responsible in the UK under the UK Bribery Act by the mere fact that I'm a UK citizen. Even though I live here and I don't operate a business in the UK, it doesn't matter. I'm still covered with that. So you may find that you're still responsible under the laws of your original jurisdiction. If you're a United States citizen, of course, you have certain requirements that you have to comply with tax and disclosure of your finances. Excuse me. Oh, sorry, Janina, can you go back? Future compliance. We always take the view at Dragon Law that you should start as you mean to go on. And this is really useful when it comes to future compliance. For those of you already with a company, you'll know that you need auditors in place to audit your financial returns, and having everything in place for the auditors is going to make your life that much easier. There's also other things that you might come across in the future. If you have investors at whatever level, they're going to do some element of due diligence. It may be that they're only investors at a very kind of low level, friends and family type stage, but nevertheless they might want to see some element of due diligence. For those of you who don't know what due diligence is, this is simply where investors will look to make sure that you've done everything by the book, everything according to the law, and that all the relevant legal paperwork, business paperwork is in place. Well, of course, if you have institutional investors, then they're going to want to do full due diligence on your books. And then regulator audit, so that might be an audit in your particular industry. For example, in my industry, in the law, you have audits from our regulators, the SRA in the UK, or an investigation, God forbid, by a particular authority, and you're not sure what that is. But these sorts of twin columns, I guess, give you an idea of ways of the reasons why you have to comply both now and in the future. I said we'll look at some key problems when minimising risk, and we put these up here as some common comments that we get from our clients and actually from our potential clients, or people that you often come across with young businesses in co-working spaces like the one we're in. Some of them, it's apparent what the problem with some of these issues is, or with some of these attitudes are. So, for example, no one will be interested in the IP of our little business. When we're big, we'll sort it out. Well, obviously, if you have intellectual property, and that's the thing that you've built, that you've grown, that you own, and then you leave it, you ignore it, then you might face problems in the future whereby effectively all your hard work has gone to waste and your intellectual property has been, for want of a better word, stolen or at least infringed upon. So probably not something that you should just wait until you're an enormous company to sort out. From a general legal perspective, the next one on the list, we're too small to negotiate terms of our supplier, so I just signed the contract, which is a very sort of, I guess, laissez-faire attitude. But generally speaking, I guess we do everything we can to protect our business. And if you get to a stage where perhaps you think, well, you know, I'm just happy to have this contract, so I'm not going to bother trying to negotiate it, or I'm just going to sign it without looking at it, then that's when you might encounter problems. There's also the issue that you might come across people who don't want to have anything written in the first place, which is another issue. But there's nothing wrong with taking your time to read a contract and to review paperwork that's going to impact on you in the future. I don't need any kind of agreement. I trust my friends. This is an attitude. Actually, it's often not expressed as such. I mean, I put that there as a quote, but I trust my friends. The reality is often your friends are your co-founders, are your mates, are your whatever. They're one and the same. But they're actually the people you're going to work with and your colleagues as well. So if you decide to go into business with somebody, and I guess you will, whether that's an investor or a partner, or unless you work as an individual freelancer or something like that, then you really need some kind of agreement, because you just don't know how things are going to turn out. Which sounds very negative from my point of view, but the idea here is, an element of protection in case things go wrong. I'll hire someone and delegate the legal work. I mean, if you're talking about hiring an in-house lawyer, then that would be very expensive. So I guess well beyond what most businesses would be able to do. If you're already a qualified attorney, then you've no problem with this. If you're just going to hire someone at the kind of lowest level and then just pass the responsibility to them, then that's where you might have some problems, because you're just kind of pushing the problems away from you and onto somebody that you employ. And if you don't get around to doing this, then you'll just leave it and things might get in a mess. I don't know what I'm doing, so I might make a mistake. Well, people make mistakes, but I guess, creating and building a business, is a learning curve. You can make mistakes, that's okay. But if you don't try in the first place, then you won't learn. And as we'll see, many things in the kind of legal area are relatively easy to deal with. Do I need to give my friend a consultancy agreement? Well, it's the same as the one below, really. I trust my friends, but we'll look at that in a bit more detail in a second. Thank you. Okay, so I'll jump straight to straight to Karen's new business. It's an online application. Called Nap App. It tells you the best time to take a nap, sleep-related guidance, and this isn't a joke. Somebody I met recently, somebody at City University, who has this as a business idea. It's not quite this, but it's really similar, which made me a little bit jealous, actually, given I'd put it in a PowerPoint slide, Give sleep-related guidance. They're thinking about employing software development company, SoftDev Limited. They've got a meeting lined up, and they want to employ their friend Terry as a freelance software developer, who's a freelance software developer rather, and he's a consultant to help manage the development. Well, I was going to ask you what you think of these, but I was going to ask you what documents you think you might need, but Janine has spoilt it for me. But never mind. This saves me having to talk for too much longer. So these are just a few ideas of things you might need to think about in that particular scenario. It's a relatively simple scenario. It's what we would call the idea stage. So might you need an NDA, a non-disclosure agreement, or a confidentiality agreement, at the point at which Cameron and Cherry and SoftDev Limited are meeting? What about after the meeting? Those of you, well, some of you may or may not have come across the expressions Memorandum of Understanding or Letter of Intent. People often shorten them down into their acronym, MOU or LOI. What about a non-disclosure agreement for Terry to sign, a consultancy agreement for Terry? What's the business structure going to be? Are they going to incorporate the company to protect their personal assets? So before you really get very far at all, there's a few different things, excuse me, and it seems like it's quite a lot of things, but actually it's all fairly simple. It's right at the very start of the business, maybe even before this company exists. There's a few things to think about just to protect the ideas around the business and protect the business itself. So a letter of intent or memorandum of understanding means exactly the same thing. It's a non-binding document, but nevertheless sets out next steps. So you have a business meeting and you decide to set out what the next steps are before a contract is entered into, or even before the next negotiations. But it's not always necessary, and may seem a little bit informal. But nevertheless, again, shows that you're kind of in control of the situation, and you've said, right, we're going to do this, this, and this. These are the next steps. And you've got something in writing, not something to sue somebody on, but something so that you can go back and say, well, this is what we agreed last time. I've just put there that some parts are binding relating to costs and jurisdiction, but it's generally a non-binding contract. Consultancy agreement. So in this particular case, we would be talking about Terry, or indeed the potentially the company, SoftDev. So obviously sets out the terms and conditions and potentially allows greater flexibility than in just employing somebody. But the key thing that I think that we always try and point out is that it ensures that the intellectual property belongs to you and your company. It was interesting, Dan and I did a talk a few weeks ago at another co-working space. I don't like to mention one when I'm in the other. But the one of the guys there said that he had a business but he had a consultant, but they didn't have anything in writing. So so this guy had some ideas, and now he was thinking about how he could formalize it. And it was apparent really that they hadn't discussed anything. There was nothing in writing about who owned the IP. So I think Dan pointed out at the time, well, in the mind of the consultant, he might have created the intellectual property. Given that there's nothing in writing, then there's nothing to allow the chap in the audience to even be able to say, well, I want to put the IP in the company, so I want to create a company and put the IP in that company, which he could do, but effectively he never had anything in writing. Certainly well worth doing. If you're developing, suppose, hardware and software and this kind of thing, you might employ consultants, and therefore you should make sure that you own their any intellectual property they create during that time. So next part of the story, NAPAP Limited is incorporated. They decide to go for an in-house development. Terry agrees to work, and they want to reward Terry for his loyalty. They want to make sure there's no disputes between them all in the future. Need to recruit a team for Terry. I then want to protect the NAPAT brand. So you're probably all already ahead of me on this one. These are, I guess the kind of next, the next kind of obvious steps at the start of any kind of, as we'd call that, the startup stage. You can jump on. Okay, we've already kind of covered employment contracts, really. I mean, the issue would be whether you wanted to employ more consultants or if you wanted to create a team and employ the team in-house as a team of employees. One thing that's certainly required would be a shareholders agreement. Which is an agreement, for those of you who've not come across it before, an agreement between all the shareholders in the business to regulate how shareholders' decisions are made, and we'll look at that in a bit more detail in a second. And how will they reward Terry? Are they going to reward him as if he's a founder, or are they going to reward him with shares? Put there a bonus scheme would be one option, but potentially share vesting arrangement. An employment contract, I won't hang around this much longer. Obviously, an employment contract, as well as a consultancy contract that we've already mentioned, can include a clause that ensures the IP belongs to the employer. And you might have something there, like I've mentioned, that includes post-termination restrictions, so where they can and can't, or who they can and can't work for after leaving your employ. What often happens is we get asked questions about, to what extent can you restrict somebody's who they work for when they've left your employ, but there are limits to post termination restrictions. You can't sack someone and say you just can't sack a salesperson and then say they could never work in sales ever again anywhere in the world. Share vesting agreements, for those of you who've not come across this before, this is a way of rewarding kind of early stage employees with shares in your business. So rather than simply give them shares, rather than effectively invite co-founders, you reward them with shares at the start, but the business has the ability to buy back those shares, claw them back, if you will. So what happens is you get 100%, your employee gets 100% of their shares on day one when they join the business, but there are certain milestones in time. So say after 1 year, the business can only buy back half the shares, and then after 2 years they can't buy back any of the shares. So I perhaps haven't explained that very well, but what this basically means that over time the person gets the shares fully vested. So let's say I start off with 100 shares in the business. So on day one, I've got 100 shares in my hand, but the business can buy back the shares at the cost price, at the nominal price of the shares, not the market price. Now, if I decide to leave the business on day two, then you don't want the employee being able to walk away with all their shares, so they can buy them all back. If they leave after year two, then the company can buy back, say, 25% of them. And I mentioned at the bottom there, share options might be another way of rewarding employees by allowing to buy shares at a reduced price in the future. But they're things that in this particular scenario you might want to think about in terms of rewarding early stage employees and co-founders. Shareholders agreement, this is vital because it deals with how you can dispose with shares, how decisions are made. I always use an example of one of my neighbours who got diluted down to 1.5 or 2% of a business that he founded because he didn't have a shareholders agreement in place. So this guy creates a business, creates the trademark, creates the idea, brings on board angel investors, and then when he decides to quit, which may not have been the best idea in the world, but when he decides to quit, they simply issue more shares, invest more money in the business, and he can't afford to buy his pro rata number of shares. So he gets kind of washed out of the business pretty easily. So the issue really with shareholder consents, whether it's there's a number of decisions which I won't go into, but whether it's a unanimous simple majority, 50%, 51% or more, and or a special majority of whatever that may be. Next. Register intellectual property. We've already kind of touched on this really. If you can register it, it might be worth registering it, but it's not fatal. Well, as I put there, it's still, what I mean there is it's still protection. You're still trying to make sure that you're protecting your idea, that you're protecting your business. It's not necessarily that you're going to end up needing to go to court over it, and hopefully you never will. We have lots of clients who register trademarks through us, and I don't. In fact, I'm sure we've never had anyone with a trademark infringement. And obviously, patents are a little bit more complicated depending on which area of, whether it's technology or biotechnology or pharmaceuticals, whatever. But that's if you're in those industries, then obviously that's a necessity. Just a few concluding ideas that I thought I'd put up. One thing's about taking the time to understand the law as it applies to you, and I put there a little time can go a long way. It's interesting, tonight we've had a couple of examples of people who've, like you have, John, who've learned a kind of lesson via doing the thing. Learning the hard way. I guess maybe that's it. So sort of learning the hard way. So even if you just take a bit of time, which is difficult when you're running a business, then that's well worth doing. Considering the law, there's number 2 there, and legal documents as actual, nothing to be scared of, just things for protecting yourself. People, often our clients to begin with, will be, I'm worried. What if I make a mistake doing this? Well, if you don't do anything, then you're going to be more exposed. But it's perfectly fine. They're easy things to deal with, and get the right documentation in place, which is obviously key. So that's my concluding ideas.